Hello students, welcome to Recitals in Depth. In this episode, we are going to cover the topics which are featured under the section of Polity and Governance for the month of November 2024. The topics are broadly falling under the broader themes of constitutional history, federalism, reservations, police reforms, important Supreme Court judgments, and governmental bodies and schemes. Now the next topic for our discussion is telecom cyber security rules of 2024. So now let's start with the discussion. So first, coming to the context. So recently the Department of Telecommunications, they notified rules by the name of telecom cyber security rules of 2024. For the purpose of the discussion, I'll be calling it as telecom cyber security rules as well. So the Department of Telecommunications, it notified the rules on 21st of November 2024 under the Act of Telecommunications Act of 2023. Now recently previous year, in the year of 2023, government had enacted this particular act, which is called Telecommunications Act of 2023, and it had subsumed three important legislations. Firstly, the Indian Telegraph Act of 1885. Secondly, the Indian Wireless Telegraphy Act of 1933. And thirdly, the Telegraph Wires Unlawful Protection Act of 1950. Because ultimately from the years of these corresponding acts, you can witness that these acts were very obsolete in nature, and keeping in line with the advancements and development in the communication technology, the Government of India tried to bring in the Telecommunications Act of 2023. And the Government of India has now notified the rules, which is telecom cyber security rules, within the ambit of this law. Now we need to understand that what is the particular aim in front of the government to bring this particular rule. So the aim is very simple. So aim in front of the government was to protect the telecommunication networks of our networks and industry of our country. And how it will do it? By bringing in certain obligations for the telecom industry, so that they should also take certain efforts and certain mechanisms should be instituted by the telecom players as well, so that it will try to immune the telecommunication industry and the networks which are being operated by such players. And that is why, to understand how these rules are going to protect the telecommunication industry and the networks from the threats of cyber security incidents, for that we need to understand the salient features which have been propounded or put forward by this particular rule. So now let us try to understand what are the salient features of these rules. So the first feature is very important, and it pertains to the data collection, usage and sharing. So under the ambit of the telecom cyber security rules of 2024, it authorizes the government to collect traffic data. That is, the kind of calls or messages that are being communicated in the entire telecommunication network which has been set up by Indian telecom players. And government has been authorized by this particular rule to collect the traffic data, and after the collection of such data, they can use the particular traffic data for their own analysis and research, so as to anticipate any kind of threat which might come up in the near future. Anticipate threats for the cyber security or any kind of subversive cyber security incidents. And third important point is the provision for data sharing. Now this rule again provides the power to the government to share the data with any law enforcement agency it deems fit, And why the data is being shared to the law enforcement agencies? So that whatever the data is with the law enforcement agencies, these organizations will be able to use such data so as to they will be able to analyze and anticipate what kind of threats are there, what kind of vulnerability areas are there, and in that case we will be able to bolster the cyber security preparation of the telecommunication network. So these are the first and the most foremost fundamental features which have been provided under this particular rule. The second point that we need to note over here is that directions to the telecom entities. So ultimately, to pursue the first objective, that is the data collection, usage and sharing, the government of India or the central government can provide very objective directions to the telecommunication entities or the telecom players to institute such infrastructure and equipments so as to provide for absolute ecosystem for the data capturing, so that ultimately the telecom player should not be in the position to tell to the central government that since we were not having the equipments or requisite infrastructure, that's why we were not able to capture the data of the traffic flow within the telecommunication network. And to help the telecom entities provide the data to the central government will be in a position to direct the telecom entities to institute and establish such equipments and infrastructure in their networks which will aid the data capturing which is flowing in the telecommunication network. The third important feature of the rule again emerges from the data sharing aspect. Now, as we know that the central government or any agency which has been authorized by the central government, after collecting the data from the telecom companies, they will be able to share it with law enforcement agencies, and the law enforcement agencies will use those data to actually get an edge over any kind of cyber security incident which might happen in the future, because they will be analyzing the data, they will be identifying the risk elements which are present in the networks. However, whenever this data will be shared, this particular rules provide that adequate safeguard has to be provided for that particular data to respect the privacy of the individuals and their data. So with respect to the privacy concerns, adequate safeguards has to be provided, that how the data which has been collected is being stored and whether it has been not provided any kind of unauthorized access, so that only the authorized persons will be able to access that particular data. And this is very important with respect to the privacy or the data privacy of the individuals. And fourth most important point that we need to cover under these particular rules is that these rules put forward certain obligations which has to be followed by the telecom entities or the players which are present in that telecommunication ecosystem. So now let us try to see it one by one. So the rule provides that the telecom entities should come up with their own cyber security policies. Cyber security and policies. And what does these policies should comprise of? It should comprise of various kind of safeguards which the companies has to take to preserve their networks from any kind of external subversive activities. Secondly, it should include various kind of best practices which are being followed in the realm of telecommunications worldwide, so that Indian telecommunication companies should be able to extract the best of the best practices which are being followed in USA or in Europe and to bring those practices in Indian telecommunication sector. Thirdly, within the cyber security policies, it should provide for better remedial actions in case of any cyber security incident if it takes place. So these are the components which should be present in the cyber security policies. The second important aspect which has been provided as an obligation to the telecom entities is the appointment of chief cyber telecom security official, whose the primary function of this particular officer will be to administer all the activities and the mechanisms which have been put forward in the telecommunication network so as to prevent any kind of cyber threats or to preserve the integrity of the cyberspace which have been created by the telecommunication sectors. The third important is the reporting norms. That it mandates, under the reporting norms, it mandates the telecommunication sector to report any incident of cyber threats which happens in their network within 6 hours. As soon as they get aware of any kind of cyber security event, they have to intimate the government within 6 hours, and the detailed report with respect to that cyber security event has to be submitted to the government within 24 hours. And the details should contain like the number of users which were affected, the nature of cyber threat which was posed, the duration for which that particular cyber network was affected, the geographical spread which was affected because of that cyber threat, and what kind of remedial measures which were taken by the telecom industry to ameliorate the effects of the cyber incident which has happened. So these are the reporting norms which has to be followed by the telecom agencies as well. And with the help of these objective guidelines which has to be followed by the telecom industries, the government of India is trying to ensure that its cyber security networks are protected from any kind of anticipated and unanticipated threats. So now let us try to, since we are done with the various features of these particular telecom cyber security rules, now let us try to analyze what are the core issues which are present over there. So first is the removal of definition of traffic data. Now, first of all, we need to understand that the Department of Telecommunications on 28th of August 2024, this year only, it has released the draft rules, and it has asked for the public consultations that various individuals, if you are interested, and any other civil society organization should provide for their own recommendation after going through the draft rules, and it will be referred to then by the government. And if the government will feel that this particular individual or any civil society organization is providing good recommendations, so they will try to include it. And after going with the draft rules, the government finally notified or came up with the final rules in November 21st, as we had noted earlier. Now, in the draft rules which the government had published, the government had provided the definition of traffic data. Under Rule 2, Clause 1, the government had provided the core objective definition of traffic data. However, the problem with that particular definition was that that wording and the language of definition was overarching. And ultimately it had led to more ambiguous interpretation of the term called traffic data, because ultimately we have seen that government can extract traffic data from the telecom industries. However, this traffic data is not comprising of the content which is present in the messages which are being shared between different individuals. However, the definition which was provided in the draft rules, it could have been, because of the nature which was involved in the definition, it could have included the content messages as well. And if it is including the content messages, that is whatever content which is being shared between two separate individuals, if such kind of data is being extracted by the government, it is a severe threat to the privacy of the individual. So that was the issue which was raised by various references which are made to the public consultation of the rules. So ultimately what government did in the final rules is that it altogether dropped the definition of traffic data. Now it creates another set of problems. Earlier there was definition in the draft rules. However, new rules, they don't have definition. So in any case, it is further aggravating and intensifying the definitional crisis which was existing earlier, because now central government has full authority to determine whatever they constitute or consider to be as data traffic. And it is always better to have some limited definition so that central government has to work within that premise. And since now there is no definition of the traffic data, central government is having the full authority to determine the scope and the relevance of what they consider to be the traffic data. So this is further aggravating and intensifying the crisis which was there in the functioning of that particular rule. Now the second important thing that we need to understand is the inclusion of purpose limitation of collected data. So under rule 3 of the concerned rule, there is a very important clause, that is limitation purpose or purpose limitation. That is, what do we mean by purpose limitation? That whatever data is being collected by the government and it is being shared with other law enforcement agencies, ultimately the purpose is limited for ensuring protection of cyber security. That is the end use of the data which has been collected by the government has been provided. So altogether it is a very progressive inclusion of within the rule that government is trying to delineate and specifically objectify that whatever data the central government is collecting, finally it should be used only for ensuring the cyber security of our country and not for any other purpose, which is very progressive. However, there are certain limitations to it. Firstly, the wordings like ensuring protection of cyber security is very, very broad. And such broad definitions can be very well misutilized by the government or any other law enforcement agencies to breach the privacy which is protected under the Article 21 of our Constitution, which is our fundamental right. So such broad definition for ensuring protection of cyber security can be a threat. Secondly, the rule is very silent on till what extent or duration the data which has been collected by central government or any agencies under the central government should be stored. Because ultimately in that case, if these kind of rules are not present within that particular rule, so any data which has been extracted or collected by the central government, they will keep on storing that data, and such collection of data and collecting it for perpetuity, it will create more concerns for privacy and for surveillance. So it might promote state-based surveillance as well. And the third is the limitation of definition of investigative agencies. That is, since the rule is silent on since the data has been collected, to what other agencies the central government can transfer those data. So the rule should be more objective with respect to what are those agencies and at what level of those agencies can the data be shared. So these are the three prominent problems with respect to the purpose limitation of the collected data, that ultimately whenever the data is being collected, how it is being used and how it is shared. And the third important point that is a problem within the operations of the rule is the reporting norms of the security incidents. So as we have already noted that the rule mandates that as soon as the company gets aware that there is a cyber security incident which has happened, within 6 hours they have to report to the government and they have to provide a detailed report within 24 hours. However, from any point of imagination, these timelines are extremely unrealistic and non-feasible for any kind of telecommunication company to create a detailed report and to do analysis, because it is creating undue compliance burden on the telecom operators as well. Now, why I am calling it as unrealistic and non-feasible? Because we have to compare it with the practices which are going on in the developed part of our world as well. So for example, in USA, the same timeline is of 72 hours. And in Europe, again, the same timeline is of 72 hours. So if the developed countries are also giving us, the telecom companies, 72 hours to actually provide for various details with respect to the security incidents, for a country like India, which is developing in nature, where the systems and mechanisms are not yet ripe, so ultimately we have to give our telecom companies certain more hours so that they can comply in a much better manner and they can provide much qualitative data to the government of India, so that they could also analyze the nature and the scope of the cyber security incidents which are taking place in our country. So ultimately these are the core issues with the functioning of the rules. However, the inclusion and the notification of such rules is a very welcome step by the government, because ultimately it is trying to protect the overall cyberspace, since more and more digitization is making place. However, the government has to make sure that such kind of loopholes has to be plugged as soon as possible. So this was all for this topic. Now let's come to the next topic, which is Know Your Medicine app. And from here itself, ultimately you can see that ultimately this Know Your Medicine app is pertaining to the domain of doping, that is the use of illegitimate drugs in sports. So now let us try to learn the content. So the first is context. So recently our Union Minister of Youth Affairs and Sports, he made a national appeal to the various sports authorities, athletes, their coaches and support personals to use the Know Your Medicine app, which has been launched by National Anti-Doping Agency, so as to know whether if any kind of medications the sport persons are using or their coaches are prescribing or the support personals are prescribing, whether they should not fall in the prohibited list of substances which is released by World Anti-Doping Agency. Now, before we go on and discuss the various features of this app, etc., for the sake of better understanding of this particular topic, all we have to do is to, first of all, we need to understand what is this WADA, that is the World Anti-Doping Agency, and secondly, we need to understand what is this NADA, that is National Anti-Doping Agencies. So firstly, again, we'll start with the global agency, that is the WADA. So the topic is about WADA and NADA. So World Anti-Doping Agency was established in the year of 1999, and it is an intergovernmental organization which was formed by 140 governments of various countries along with International Olympic Committee, and its entire motive was to promote, coordinate and enforce non-use of drugs or dope in sports in the country. Now this particular agency WADA is based in Canada and its headquarters is located in Montreal. And its primary vision, the vision of the WADA, is to create such kind of environment for the athletes and various sportsmen so that they can participate in various sporting events without the fear that other athletes are involved in any kind of usage of drugs which is artificially enhancing their performance. So ultimately the vision is to create a drug-free sporting ecosystem. And to fulfill its vision, the primary role the WADA performs is the development, formulation, harmonization and enforcement of anti-doping rules for all sports and for all countries, because ultimately it will be the objective and the key role of the World Anti-Doping Agency is to come up with such anti-doping rules which will apply for all the sports and across all the countries, because different sports require different kind of medications as well, and they hamper or accentuate various kind of physiological performances of athletes in different manners, and that is why it is the role of the WADA for the development, formulation and harmonization, because ultimately different countries has to be administered and regulated in different way. So anti-doping rules has to be instituted in such a manner that it is followed across the sports and across countries. And to help the WADA in completion of this primary role, they are taking care of certain activities, which is they are getting involved in more education and research of the various therapeutic effects of various substances and their effects on the sporting performance of the athletes. The second is they also involve in various kind of investigations and inquiry if they come across any kind of intelligence with respect to doping activities are taking place in certain countries. So they will definitely go for investigation and inquiry and research. Thirdly, they provide for capacity building of anti-doping agencies across the world. That is, the WADA will work with the anti-doping agency of our country. And what is the anti-doping agency of our country? That is the National Anti-Doping Agency, which again functions under the ambit of Ministry of Youth Affairs and Sports. So again, that was the core topic that we had discussed, and this was the NADA itself which had created this app which is known as Know Your Medicine app. So it is also one of the activities and functions of WADA to provide for capacity building of various national anti-doping agencies. So it is collaborating and coordinating with national anti-doping agencies of not only of India but also of other countries like Chile or Italy or say for instance Bangladesh. So these are the core activities which are being performed by it, and one of the last activity and one of the most important activity is publishing of prohibited substance list. Prohibited substance list. So WADA annually it publishes this particular list which contains the list of substances which are prohibited to be used in competition and out competition. And we need to understand what are these two terms. So in competition, it means that while the competition is going on, the athlete cannot take it. For example, in competition starts from 11:59 p.m. from the day before of day of performance, and it goes till end of athletic event. So that is called the in competition, and out competition comprises of time duration which is not overlapping with the time duration which has been prescribed by the in competition. And ultimately those substances are included in the prohibited list which has been published by WADA if they comprise of minimum 2 of the 3 criteria which has been published by the WADA. First of all, it enhances the performance if a drug is found to be enhancing the performance. Secondly, if it is posing any kind of health risk to the athletes. And thirdly, if there is any substance which is hiding or obscuring the prohibited substances. So there are certain substances which various kind of unethical sports persons take that obscures or hides whether a particular person is taking any performance enhancing drug. So if any substance is found to be qualifying the eligibility of at least 2, then these substances are placed in the prohibited substance list which is being published by the WADA. Now since we have understood the various functions of WADA, now the NADA is nothing but the parallel agency which is functioning under the ambit of government and trying to enforce various rules and norms which have been put forward by the WADA. So NADA is nothing but the National Anti-Doping Agency which was established in year of 2005 as a society, and it is functioning under the ambit of Ministry of Youth Affairs and Sports, and its functions are twofold as we already noted. That is to enforce anti-doping code, and secondly to go for testing of athletes so as to enforce and to inquire whether the athletes are not involved in any kind of doping activities. Now recently this NADA has notified this particular app known as Know Your Medicine app. And what is the primary function of this particular app? Is that it is complying with the prohibited list which is published by WADA. So it provides the opportunity for any athletes to know whether if they are consuming any kind of medication or any kind of supplements or food supplements that they are using, which their coach must have told them or any support personals or nutritionist must have told them. And sometimes it happens that without any intentions, they are consuming such content or such substances which are included in the prohibited list of substances. However, the sport person is not aware of it. And so many times it happens that the sport person is inadvertently, they are consuming any substance which is present in the prohibited list and they are not aware of it. However, whenever they go to the sporting event and when there is a doping test and they turn out to be positive, and it becomes a very disastrous and unfortunate situation for the sport person as well, since they have been working with a lot of integrity and honesty. However, because of the lack of awareness about the substances that they were consuming, they did not know that they were actually violating the norms which has been put forth by the WADA. And to bridge this information gap, this NADA has come up with Know Your Medicine app, which provides for various kind of medicines which are prohibited under the WADA, and any athlete which is using that app, they just have to fill in the kind of like person they are and what kind of sports they are playing and what kind of medicine that they are using. And by this usage of this particular app itself, this app will say that whatever components you are using, whether they are very clean or they are included in the prohibited list of substances which are published by the WADA. So ultimately, this medicine app is a very good app in a way, so as to provide information to the athletes so that they do not violate the norms of WADA. So this was all about this topic. Now coming to the next topic, which is the bulldozer justice. Now this is again one of the most important topic which has featured in this month's recital. So now let us start with it. So coming to the context, so recently the Supreme Court, utilizing the powers which has been provided under the Article 142 of our Constitution, that is, it provides the power to the Supreme Court to provide such judgments or to provide such directives so as to secure complete justice. That is what the Constitution reads. Okay. Now, what did the Supreme Court do in this case under Article 142 is that it provided directives to the municipal authorities across the country so that these directives are to be followed if they have to provide for demolition of property of any accused person. So what we will try to learn and understand in this particular topic is that what happened in our country and in our social sphere that the Supreme Court had to utilize the Article 142, which usually Supreme Court does not do. And in very rare to rare circumstances, the Supreme Court tries to utilize the Article 142 of our Constitution. So what were those conditions and circumstances and situations which were taking place in our country, which provided a compulsion to the Supreme Court of our country to provide such directives to the municipal authorities and corporations of our country? So now let us try to understand the story, and the story starts with the term of bulldozer justice. So in the last 3 years, specifically starting from say January 2022, what had happened that there was an event in the sleepy town of Khargon, which lies in Madhya Pradesh. So what had happened is that there was a person, say X, and this person particularly belonged to a community, a specific community, a minority community, let's say. And this particular person X was apprehended by the police authorities for putting pieces of meat in the temple. So definitely it is a very unfortunate event and it is not at all a good activity. So that is why the person X was apprehended by the police. However, what happened, and after the apprehension of the person X by the police charged with the relevant sections of the Indian Penal Code and currently the Bharatiya Nyaya Sanhita. However, and the process the police charged with them with several crimes, like for example instigating enmity between different communities, since this particular person, he threw pieces of meat in the temple. So ultimately it is creating religious animosity between different communities. So ultimately police charged the particular person with relevant sections. However, what happened is that the place or the property in which the particular person X was living, it was demolished. Demolished the same day. Same day by the municipal authorities. So what problematic thing that occurred to the various civil society activists and to the courts of our country as well is that two important things were there. Firstly, why the government was so eager to demolish the home of the perpetrator named X. The home or the property in which the particular person X was staying, the government claimed that this property was violating the norms of the Municipal Corporation Act of Madhya Pradesh, and that is why through that particular act it has provided the power to the municipal authorities to actually demolish the areas which were violating the building norms. So why ultimately the ultimate eagerness was there with the municipal authorities to demolish it after the X has committed the crime? And secondly, it provided for a collective punishment as well. Now, since we already know that the particular person X was apprehended by the police and was taken into the police custody, and he was charged with relevant sections of the Indian Penal Code as well, for example promoting enmity between different religious groups. However, what do we mean by collective punishment is that his family of person X was staying in that particular home, and now because the entire house was demolished, by claiming of the municipal corporations that they were trying to remove the encroachments or the building was not following the stipulated norms which has been provided by the Municipal Corporation Act. So ultimately now the entire family is bearing the burden of the conduct of Mr. X. So ultimately it is also breaking the principle of natural justice. And thirdly, it is not very difficult to observe that such kind of activities by municipal corporations, it provides for a flavor of majoritarianism along with subversion of rule of law as well. And this incident which we just discussed belonged to the city of Khargone, which lies in MP. However, since this particular event had started, entire country, like various places in our country, they witness similar kind of incidences. Whenever a person of a particular community who is belonging to the minority was involved in any kind of like activity which goes against the law, it was observed that in similar kind of situations, not only that particular person was charged, which was the legal procedure. However, the municipal corporations or the councils of those areas, they were trying to demolish the properties in which those perpetrators were living, and these actually created a very difficult situation for the courts of our country as well, and various like proponents of fundamental rights of our nation as well, that they were alarmed and they were appalled by the state of affairs which was going on in our country. And that is why the Supreme Court, after observing the state of affairs for almost 2 years, they came up with a very objective guidelines with respect to what kind of procedures and due process has to be followed by any various municipal corporations or authorities before they could actually demolish the properties of perpetrators. So this was the entire story of it. Now let us try to understand what did the Supreme Court observe with respect to the ad hoc demolitions which were taking place. So Supreme Court noted that ultimately such kind of activities is an absolute perversion and subversion of the principle of rule of law. Why? Because ultimately there was no due process. Now since any particular person who committed any particular crime and the next day their entire property is being demolished by claiming and by the claims of the municipal corporation that they are doing it just because they are trying to remove any kind of encroachment. Now the concerns with respect to the families of such like places which has been demolished is that they were not provided any say opportunity to argue for their own case, or they were not informed earlier that their places were violating certain norms of the Municipal Corporation Act, or they were violating the norms of Building Act. So ultimately there was no due process and no rule of law, and rule of law is one of the most founding principles of our constitution. Secondly, there is a lack of separation of power. Now ultimately it is under the doctrine of separation of power, it is the role and function of the judiciary of our country to provide for various punitive measures. And secondly, it is the executive which has to provide for the implementation of the various policies which has been designed by the government. Now here in this particular case, what is happening is that judiciary is taking its own course to provide for the punitive measures. However, it is the executive, that is the municipal authorities, they are also punishing it by rule by law. That is, they are using the law as an instrument of coercing the other person or harassing the other person, and ultimately it is violating the doctrine of separation of power. The third is, it is also breaking the principle of natural justice as well. That is, since the family members of the persons, they were not provided any opportunity to argue for their case that why their building was being demolished. Secondly, the family persons, they were not informed earlier, there were no notices. And thirdly, the municipal authorities, they were just claiming that they are trying to remove the encroachments which is illegal. So such kind of things are also breaking the principle or violating the principle of natural justice. The fourth important observation which was made by the Supreme Court, it goes against the various orders which the Supreme Court has provided with respect to the shelter rights, that ultimately it is provided, such kind of activities is providing for collective punishment. That is, if a particular person X has committed the crime, and if that particular person X belongs to a particular community, then not only that particular X person will suffer, the entire family will suffer. And that is why this collective punishment term has been used. And ultimately, whenever the demolition is taking place of a particular property, it is hampering the shelter rights as well, which has been declared as fundamental right under Article 21 of our Constitution by various Supreme Court judgments. And lastly, Supreme Court also observed that such kind of bulldozer justice is also reeking and smelling of communal flavors. That why such demolition is happening towards the property of a particular person who is belonging with a particular community, and why it is not happening with others. And secondly, why there is so much eagerness that municipal corporations are hell-bent to demolish the property, and why they were not demolishing the property earlier before the particular person had committed the crime. So this itself shows that there are definitely malified intentions with respect to the municipal authorities, and the majority community as a whole is trying to collectively punish the entire family and the community as a whole. So based on these observations of the Supreme Court, utilizing the power which has been provided to them under Article 142, they came up with specifically binding directives on the municipal authorities. And what are those directives? Firstly, a 15 days notice. 15 days notice has to be provided to the families for which the municipal authorities are trying to demolish, and that particular notice should contain all the details with respect to why the municipal authorities are trying to demolish it, with respect to what violation of norms or laws are being taken place through that property. Secondly, what date are they trying to demolish it, and the details of laws which are being violated, and what kind of response are they expecting from the owners of this property, and what kind of documentation they will require so as to understand whether they will be able to demolish it or not. And lastly, it will also have the date of personal hearing by the municipal authorities. That is the date of personal hearing. That is, the municipal authorities or the officials concerned will be providing opportunity of personal hearing to the owners or the custodians of those properties. The second important aspect which was provided by the Supreme Court directive was that it directed all the municipal authorities to construct a portal or a digital portal within 3 months, which will contain all the details of notices which are sent for demolition, the replies which they got with respect to the demolition, and thirdly, the final orders for the demolition, so that ultimately it will be providing access to the public and ensuring the principle of transparency in the total functioning of the orders. One more thing which we need to note in the point 1 is that as soon as the 15-day notice is sent to the property owners for which the property is going to be demolished, the same digital acknowledgement of that particular notice has to be sent to the collector office as well. Why? So that collector office will be a repository of the various acknowledgements which has been received by the property owner, so that any official with any willful malified intention should not be able to use the backdate, so that backdating of any kind of documents will not be able to take place. The third is the personal hearing. In the personal hearing, ultimately it is providing the opportunity for the property owners to argue their own case, and the Supreme Court directive holds that whatever is being discussed, it has to be recorded as a very objective instrument of law itself. That is, whatever argument is being put forward by the owners of the property that why their property should not be demolished, it has to be recorded in a very objective and official manner, and it has to be preserved with the municipal commissioners as well. The fourth is final order of demolition. Now, when the personal hearing is done, the municipal authorities has to provide for the final order for demolition, in which it will absolutely objectively note that the reasons why the municipal authorities are going for demolition, and they will also provide the reasoning as in for why the alternative methods like partial demolition or compounding of offenses are not being used, and municipal authorities has to provide very objective detailed reasoning as in why they are using the method of demolition only to bring that particular property within the legal norms. Fifth is the review guidelines or judicial review. So it provides, the Supreme Court directive provides that 15 days should be given to the owners of the property to appeal against the final order of demolition, whether to the Supreme Court or to the higher municipal authorities. And lastly, it has also provided guidelines with respect to the demolition drive, that whenever the demolition is being taken place, it should make sure, municipal authorities should make sure that it is being video recorded, and there has to be a detailed demolition report for every demolition which is taking place. And that detailed demolition report will comprise of details like the timing of the demolition, the various kind of civil and police officials who were involved in the demolition, and the video recording plus the report has to be put in this particular portal, so that again it will be available to the public so as to ensure more transparency. And since the entire report will be present in the public, they will be able to hold the various errand officers to be more accountable. And these were the core Supreme Court directives which were put forward by so as to preserve the right to property of various individuals with respect to the property that they are holding, and secondly, such kind of directives will inhibit any kind of arbitrary and ad hoc knee-jerk reaction by the municipal authorities and it will result in curbing of the various majoritarian impulses having certain communal undertones from demolishing the properties of people belonging to minority communities as well. So this was all about this topic. Now let's come to the next topic, which is why is census crucial for delimitation and women's quota. So again, it's a very important topic, and as we know that the census, as it is a decadal exercise, and because of the COVID there were certain delays in the conducting of the exercise of census. However, now the government is trying to consider whether to go for the census in this particular year of 2020, in the coming year of 2025. So now let us try to understand what is census and how the conducting of census is actually linked to the exercise of delimitation and to the process of women's reservation, which has been put forward by the 106th constitutional amendment of our constitution. So now let us first start with what do we actually mean by the census. So census is the exercise of collecting, compiling and analyzing certain set of very important data of the individuals who are residing in our country. And what data are they trying to collect, compile and analyze? So it forms in three categories. Firstly, the demographic data. Secondly, the social data. And thirdly, the economic data. What do we mean by demographic data? So the demographic data will comprise of the age of the individual, the sex of the individual, their literacy levels, etc. Okay, what does the social data means? Which religion they belong to, whether they belong to SC or ST category. Now with respect to the economic data, it comprises of various housing data, the economic activity in which people are involved. So such kind of data are being collected, compiled, analyzed and finally disseminated by the government of our country to achieve the final objective, which is to create a central data repository, central database. And what will be the utility of this centralized database? Which will aid in effective policy making. That is the core of the core requirement, because for the government of India to secure its citizens, the promises it has made to the citizens in the preamble and in the constitution as well, it needs very granular and very correct data. Then only the government will be able to design policies so as to redistribute the resources which is being governed by the government of our country, and to provide opportunities and avenues for the socio-economic development of not only scheduled caste and scheduled tribes, but the entire ecosystem and the economic system as well. So ultimately that is the core essence with respect to the census. And it is needless to say that we know that census is a decadal exercise, that it takes place every 10 years. Now with respect to the governance aspect of census, so with respect to the constitutional understanding of census, so population census as a subject is mentioned under the union list under entry 69. With respect to the law, there is a specific law called as Census Act of 1948, which governs the various provisions with respect to the functioning and conducting of the census. Lastly, the administering authority, it is done by the Registrar General of India. That is the core office which takes care of the administration of the entire exercise of the census. And this Registrar General of India, it functions under the ambit of Ministry of Home Affairs. Now coming to certain operational aspects that we need to know with respect to the census or how it is operationalized. So the census consists of two phases. In the first phase, the census of any year, it starts with housing census. That is, under the first phase, that is the housing census, the enumerators or the data collectors or the grassroots level workers, they try to go on through the various areas. They try to map the number of households which are present in a particular area for which they have been provided the responsibility. And secondly, within every household, they try to find out the level of amenities which are present within that particular household. For example, whether there is an tap connection for water or not, whether there is an electricity connection or not, whether there is LPG gas connection or not. So such kind of data with respect to the amenities of the households are recorded. Now, as soon as this phase 1 of census is done, which is the housing census, after a gap of 6 months and utilizing whatever the data we could generate in the first phase of housing census, then the second phase called the population enumeration begins. Population enumeration or the population census begins. And by utilizing the various kind of data that we already have with the help of housing census, that is, the enumerators already know that how geospatially the population is distributed, and then the data which is already accumulated with respect to the amenities which are present in the household, based on those data, the enumerators then they will go for collecting other facets of the data of the individuals which are residing in our country, as we have already discussed, whether be it the demographic data, the social data or the economic data. So these are the core operational processes which are being followed while conducting the census in our country. Now, why we need to understand over here is that how census is linked with delimitation. So what do we mean by delimitation? Delimitation means to determine the number of constituencies for parliamentary elections or for state legislative elections, and secondly, to determine the extent of territorial jurisdiction of a particular constituency. And thirdly, to distribute seats, total seats among SC and ST communities, since it is reserved by the constitutional obligations of Article 15 and Article 16. So these are the core three components of the delimitation exercises, which comprises of to determine how many number of constituencies has to be there for parliament and state legislative elections. Secondly, about the determining the extent or the geographical extent of those constituencies, and thirdly, to determine the distribution of total seats within the SC and ST communities as it is mandated by the constitution of our country. However, to determine the number of constituencies, we need to ultimately depend on the data of the census, because ultimately it is the census which will be calculating the population of our country, and based on the population only we will be able to determine the number of constituencies which has to be created for the parliamentary elections and the number of constituencies which has to be created for state legislative elections. Why? Because ultimately the principle which is being followed in the delimitation exercises while deciding the number of seats either for parliament or state elections is that there has to be a fair representation. That is, ultimately every constituency should reflect roughly equal number of people. And secondly, every elected representative should represent equal number of people. And that is why ultimately that is the whole calculation which is being governed by this principle, that whether a particular person who is being elected to parliament from Uttar Pradesh or from Kerala, these two representatives will try to represent equal number of principals, and that is the core principle of parity, which is to be followed for more democratic distribution of the constituencies in our country. And now let us try to come to the current status of delimitation in our country. So Article 82 and Article 170 of the Constitution, it provides that the delimitation exercise has to be conducted after every census. So, in pursuance of the provisions of the Article 82 and Article 170 of our Constitution, the Delimitation Commission has been constituted 4 times since our independence. First was in 1952, then in 1963, then in 1973, and finally in the year of 2002. Now, the same question, that how many times the Delimitation Commission has been formed, it has been asked in the year of 2024 prelims itself. So such kind of things are very important from the prelims point of view as well. Now, to understand it, that ultimately after the completion of census of 1951, the delimitation activity was taken care in the 1952, similarly for 63 and similarly for 1973. However, in the year of 1973, by the 42nd Amendment of the Constitution, the number of seats for the Parliament, it was frozen to 543, and it was extended till the year of 2000. However, by the amendment of 84th Constitutional Amendment, this timeline was again extended till the year of 2026. So that it said that the 84th Constitutional Amendment, it said that whatever census is being done after 2026, it will lead to the development of new number of seats for Parliament. That is, based on that census, we will determine the new Delimitation Commission and similarly the number of seats which has to be given to the Parliament. So based on the population of 1971 census, the number of seats which are there in the Parliament is 543. And based on 42nd Constitutional Amendment and 84th, whatever census is being taken place after 26, based on that, the new delimitation exercise will take place and the new number of parliamentary seats will be provided. So this is the core linkage with respect to the operation of census and the delimitation exercise. Now, let us try to find out the linkage of the census and the women's reservation. Now, as we know that by the 106th Constitutional Amendment Act, the Parliament has provided that 33% of seats will be reserved for women both in the Parliament and in the state legislative assemblies. However, this provision of the 106th Constitutional Amendment will be applicable only after the data of new census is being provided, and based on that data of the census there has to be delimitation, and then only we will be able to bring the provisions or the progressive provisions for the representation, enhanced representation of women in the Parliament to reality. And that is why the census is absolutely linked with women reservation, because we will be able to provide the constitutionally guaranteed reservation to the women in Parliament and state assemblies only when we conduct elections, and then only when we conduct census, and based on that data which has been provided by the census, we will be able to go for delimitation and then the enhanced representation of women in our Parliament. Now, it has been noted by various social activists and political commentators that the government is going for undue delay in the conducting of the census, which has been a very decadal exercise. And it is understandable on the part of the government that since there were very difficult times during the time of COVID, it was not feasible for the government to come up with census. However, now since almost 4 years have passed after the onslaught of the COVID, now the government is finding the accurate time to actually conduct the decadal exercise of the census. So this was all about this particular topic. Now let's come to the next topic. So the next topic is National Company Law Tribunal. So why you are trying to learn this topic? So recently Supreme Court highlighted in one of its judgments that National Company Law Tribunal is often working with inadequate human resources, and there is a dearth of infrastructure which is available to the National Company Law Tribunal, which is hindering their functioning. So in this context, now let us try to understand the composition and the function of this particular institute. So this National Company Law Tribunal is a statutory quasi-judicial institution which was created in the year of 2016 after it was merged, or rather it subsumed within itself the Company Law Board and Board for Industrial and Financial Reconstruction. And this particular organization is formed under the Companies Act of 2013. And what is the core primary purpose of this particular organization? Which is to resolve corporate disputes of civil nature arising under the Companies Act of 2013. It is also adjudicating matters which is related to the insolvency and bankruptcy under the Bankruptcy Code of 2016. Now coming to the origin, so ultimately the genesis of this National Company Law Tribunal was provided by Iradi Balakrishnan Iradi Committee to address insolvency and winding up of companies. And how does this particular structure of this organization is structured is that the NCLT has a principal bench in New Delhi and other benches in various other different cities like Ahmedabad, Bengaluru, Chennai, Kolkata, and each bench is headed by a retired judicial member as president or a serving high court judge along with assistance from a particular personnel from the Indian Corporate Law Services. Now coming to the core powers and functions of the NCLT. So firstly, it is providing very flexibility in procedure, that NCLT is authorized to determine whatever procedures they want to follow, that they are not going to follow the various procedures or civil procedure code. However, they are going to follow the process of natural justice. Now similarly, with respect to the order enforcement, it enforces orders with the same authority as that of a court, since it is a quasi-judicial organization. It has also got review powers, that it can scrutinize and review its own judgments. With respect to the procedural regulation, the NCLT can provide for regulation of their own procedures. They can change and amend the procedures which they are following according to the need of the time. And lastly, about the insolvency adjudication. So it serves as the adjudicating authority for insolvency and resolution processes of companies and limited liability partnerships under the Insolvency and Bankruptcy Code of 2016. Now with respect to the appeals, what kind of appeal and where do we have to appeal? After the National Company Law Tribunal has provided its judgment. So any individual or entity can appeal the judgment of the NCLT to the National Company Law Appellate Tribunal. And ultimately, if they have to go again against the judgment of NCLAT, then only they can approach the Supreme Court of our country. Now what is the significance? Now it is very easy to understand the core significance of this particular organization, which is that it plays a crucial role in streamlining the resolution of corporate disputes and insolvency cases, ensuring faster and more efficient justice for the businesses. Ultimately, it will lead to more ease of doing business, since this institutional arrangement is providing for dispute resolution at a very cheap manner and as a very expeditious manner. So that is why National Company Law Tribunal is a very important organization vis-a-vis the ease of doing business in our country. So now let us come to the next topic. Now the next topic for our discussion is the Press Council of India. So what is the context? So recently, to recognize the various efforts which the media have made in the socio-economic development of our country, the National Press Day was celebrated on 16th of November to honor the various efforts which the media has paid in the socio-economic development of our country. And apparently this 16th of November is being chosen as a National Press Day because it is the same day when the Press Council of India began its operation. And that is why we are here to learn about the Press Council of India. So Press Council of India is a statutory organization which is formed under the Act of Press Councils Act of 1956, and it was based on the recommendations of First Press Commission, which was headed by J.V. Mudholkar. And ultimately this Press Council of India is acting as the watchdog to protect press freedom and the journalistic ethics in our country. These are the two important core objectives which it wants to achieve for the press in our country. Now, with respect to the composition, the Press Council, it comprises of a chairman, which comprises of a retired Supreme Court judge, and this judge is selected by a committee which comprises of chairperson of Rajya Sabha, Speaker of Lok Sabha, and a member representative of the council itself. Apart from it, there are members to the Press Council of India, which comprises of 28 members, and these members belong from various fields in the field of press and journalism. It comprises of various journalists, newspaper agency owners, etc. Now, coming to the powers and functions with respect to the Press Council of India, it has got three core prominent functions. Firstly, the regulatory functions. Secondly, the adjudicatory functions. And thirdly, the advisory functions. Now, as it is very easy to imagine from here that ultimately being the peak watchdog of press freedom and journalistic ethics in our country, the Press Council of India, while performing its regulatory functions, it provides for certain guidelines which various press agencies has to follow while conducting ethical journalism. For example, in the year of 2023, it has provided for the guidelines for effective representation of the LGBTQ community in the media. Similarly, in the year of 2022, it has provided guidelines for how to cover incidents of natural disasters. For example, the natural disasters, whenever the journalists are covering the events of natural disasters, a great degree of accuracy is required so that it does not create unnecessary panic and fear in the society. And secondly, accuracy of the information and empathy with the victims as well, that ultimately while conducting and gathering the information, they are not harming or further perpetuating the pain of the victims. So such kind of regulatory regimes and norms are enforced. Secondly, since it is a quasi-judicial organization, as the powers has been provided through the Press Council Act itself, so it looks and investigates into violation of various kind of like if a journalist is found to be flouting the journalistic norms, so in that case it will act as an adjudicating authority and it will try to issue warnings, and it might admonish any kind of journalist or newspaper agency And with respect to the advisory, it advises the central government or the state government also if they are formulating any law which has bearing on the press freedom. Now, what we need to understand is that there are certain limitations also in the functioning of Press Council of India, and one of the fundamental limitation is in the adjudicatory function which the Press Council is performing. Why? Because ultimately the Press Council of India cannot penalize or punish any errant journalist or newspaper agency. Rather, it can only summon warnings or it can admonish them. So ultimately, the directives which are being provided by the Press Council of India to the errant journalists and the newspaper agencies are carrying only the moral weight and not the punitive weight. So it can only provide right directions. However, there might be instances that even after getting several warnings by the Press Council of India, those errant journalists are again repeating those same patterns and behaviors of unethical practices in the journalism. So these are the core limitations with respect to the functioning of the Press Council of India. So this was all about the Press Council of India, and since this was the last topic as well, so this was all about this month's recital also. I hope you found this session to be enriching and an informative session. Stay tuned for the next one. Thank you.